Is it? Just about.
Sorry, yeah, I'm Toby, you're... That's the one.
I'll take your badge.
She's going to take whatever you like, mate.
Alright. Right, a couple of questions, first of all. Who printed this off? Right, so that's what was issued to the property yesterday.
Yesterday?
Yeah, it was put through yesterday.
Wasn't put through yesterday at all. That was put through a long time ago.
Right, okay.
First
But
of
this,
January.
because I spoke to the court earlier, and they said, you said earlier, you put 8 o'clock on all of these documents.
Yes, we do.
That's the time you need to leave the property by.
But the eviction will take place.
The time you need to leave the property by, so you can go to the council and be rehoused if you need to.
It says there the eviction will take place at 8 AM. But when we spoke to the court, it was ordered booked for 12 o'clock.
That's the time that we will meet with the claimant. The time that they need to leave the property is 8 o'clock.
What document have you got that you're relying upon to be trespassing the property as we stand?
We're not trespassing the property. We have a warrant for possession of the land, which gives us the authority to be on the land.
Right, so this is the warrant number. So what is the date that warrant was obtained? Because I believe that warrant number is the same warrant number that has already been executed 2 years ago.
It wasn't executed 2 years ago. This warrant was issued on the 26th of July 2023.
Yeah, so there was an attempt.
No, there wasn't an attempt. There was a discrepancy with the.
What's that, mate?
That's mine. Thank you. There was an issue the last time the bailiffs attended. There was an issue with the address. It only had 35C on it. The actual order is for the whole property, 35, right. And that's why it wasn't executed last time.
So the
claimants have had the possession warrant amended to 35, and that's why we're here.
Right. So where is the actual order that grants you authority to take possession? Because that's a warrant.
That's just the warrant, yeah.
Yep.
The order's at the court.
That's we don't
need to carry the order.
You need to prove that you've got authority to be here.
There's the warrant. We're in possession of the warrant, and the possession of the land. We have the authority to be here.
But even in the criminal courts, a warrant, the possession order, the eviction order.
We're not criminal court. We're civil court.
Yes, I know. But this has been proven.
There is a seal.
There's no.
There doesn't have to be a seal on that.
Yes, it does. CPR.
No, there doesn't.
That's
it's not an eviction order. That's a notice of an appointment.
You need to provide.
Does not have to be a seal on that letter.
A sealed order, notice of eviction by the court for possession.
That would have been sent to. That would have been sent to these premises by the court. It doesn't come from us. It comes from the court itself.
No, because you're enforcing it. You have to prove. You need to provide that. You need to prove that you've got the authority by the documentation that you're enforcing. Well, you need to have that with you. If you haven't,
the warrant is the authority that we have.
No, it's not. That's
absolutely
not. Even in a criminal court, hold on. That's not acceptable in even in a criminal case. I've been in 3 trials where the judge has ordered the bailiffs to produce the documentation, the warrant, the notice of possession or eviction that they relied upon that grant them authority to force entry to the property. On all 3 occasions, the bailiffs provided that warrant to the judge, to the Crown Court judge, and he said, that isn't the warrant. I need the signed warrant, the order from the judge. That's a warrant.
That's the warrant.
That's a warrant. Admittedly,
that is the warrant that gives us the authority to carry out this possession state.
You need to produce.
Can I just ask you a question?
Yeah.
Because obviously you've done a lot of talking since we got here.
Yeah.
Are you going to prevent us from entering that property today?
You are not allowed to use force.
Unless you can provide us with the authority and the order signed.
So you're obstructing an officer of the court.
You are not allowed to use
force. I'm well within my right to ask you for you to provide the authority you're relying upon to be trespassing on this property, or what you're relying upon, that you believe that you've got the authority to force entry to that property.
Well, we can go, if you want us to go back to the court and get a copy of the order, we're more than happy to do
that.
There's
no court seal on that.
There does not have to be a court seal on that.
Who said that? Who said? Are you saying this?
Hold on, let's not have too many people talking at the same time. There's under CPR 40.4, it states, you've got the CPR on your phone, haven't you?
That the order has to have
a seal from the court.
What we will
that warrant.
If that's what you're saying, okay, I'm more than happy to go back to the court and get a copy of the order and bring it back here and show it to you, and then this eviction will go ahead.
Believe it or not, I'm trying to look after both of you because I want to make sure that you don't do anything unlawful or illegal.
We are not doing anything unlawful or illegal at all.
But if this goes into the criminal court, it will get proven beyond reasonable doubt that you never had authority with that documentation. You never had authority to force entry or take the property. I know you're following orders, and you might have done this. You might have done this before, but this is just because you've done it before and it's common practice doesn't mean to say it's legal or lawful. I'm just making sure that you do your due diligence. I know for a fact, criminally and civilly, that you have to provide and produce the order from the court with the name of the judge that has granted the order, that's given you authority to take the possession or evict the occupants of this property.
I'm willing to go back to the court now and get a copy of that order and bring it back.
Can you also confirm that you're aware that as a High Court enforcement or a County Court bailiff, you are not allowed to force entry to a residential property? That's in the House of Commons.
The warrant of possession of land gives the claimant's agent...
Where is the claimant's agent?
What's it give you?
The agent for the bank. Locksmith isn't an agent for the bank. Can you provide the authority that you're here representing the bank, please, by documentation that's been... No, I need the physical... You need to produce the physical documentation that the claimant has authorised you to act for the claimant. And what is the name of the claimant? Because Bank of Scotland... The Bank of Scotland is a company, it's a corporation, it's a building, so it needs to be the name of the claimant that has authorised you as a name. What's your name, please?
Marco.
Mark what?
Marco.
Marco what?
Marco Cella.
Cella. Marco Cella. And who do you work for?
I represent the bank.
Yeah, no, who do you work for? Because you're a locksmith, so you work for a company. What company do you work
AMG Maintenance.
for? AMG Maintenance, and where are they based?
Where's
your office?
My office in East London.
Right, yeah, but what's the address? Because we need to see proof. Because these guys can't. Hold on a minute. These guys can't force entry to the property until you satisfy these two guys that you have got instruction and been authorised by the claimant. By the claimant.
Yeah.
So by the claimant.
AMG.
No, the claimant has instructed you. The name of the person that's brought the claim, his name instructing you to act on his behalf. Because it's almost like power of attorney. He's given you his instruction for you to act. For him not being here today, it's almost like him giving power of attorney to you to act for the claimant. And unless these two guys are satisfied that you have got valid documentation to prove that you're acting in the capacity... No, forget about the warrant.
Are you legally trained?
I'm not talking about the warrant.
Are you legally trained?
Hold on, I'm not talking... Hold on.
I used to advise government on property.
That's not what I asked you.
Hold on. Let's not divert away from this. Listen, can we keep it on point? These guys have got a job to do, and providing that the warrant, the notice of eviction, is being lawfully executed, given to them, authorised by the court, for them to carry out.
I'm not there, so I don't know.
Yeah, I know, Marco, let me explain to you what the process is, because I understand the civil procedure rules and due process. I know exactly what box needs to be ticked to get it to where it gets to. And if you're acting as an agent for the bank, for the claimant, you need to satisfy these two guys because they can't just come and take the property. You can't come and use your lot to break into the house without providing any evidence to me, two guys, that you've got the authority, you've been instructed to act for and on behalf of the claimant, the Bank of Scotland. And unless and until you do, we'll be looking at calling the police and having you arrested as a trespasser because you need to satisfy not just me, but these two guys and the court the capacity that you're acting. I'm trying to deal with this. Yeah, no, listen, we're trying to deal with this amicably between us to make sure that everything's all above law. So, as it stands, you need to be satisfied that this gentleman here has got instructions, signed written documentation from the claimant, Bank of Scotland, that's instructed you to act here in the capacity as agent for the bank. And unless you can, then you're trespassing.
See what we're going to do? We're going to go back to the court now and we're going to get a copy of the order, okay? With all the information on it that you want to show you when we come back, all right? I'm going to speak to this gentleman as well about postponing it for the time being this morning. Obviously, I've got to tell the bank that as well because they've instructed us.
If you're going to speak to the claimant...
Excuse me just a second, sorry, just a second. We're the neighbours of this house, so we have a party wall in common.
Right, okay.
We've been very concerned tiles fell off the roof onto our footpath during that last storm, which would have killed anybody passing.
Yeah, absolutely.
There's more tiles that are loose. The property is therefore dangerous. I have reported it to the council.
Okay.
I have been in touch with I understand, the recipients of the property according to the land registry. And I've been in touch with them, and they have said they are going to respond to me as an interested party.
Well,
all I'm saying.
The reason we're here
Yeah.
today is that's completely nothing to do with us.
No, I appreciate that. I'm just explaining why I'm filming you.
Right, okay.
And obviously I would be very grateful if I could be kept informed as things progress.
To be honest with you, sir, as you're not a party to the case, as these gentlemen aren't either,
No.
we're not
I appreciate
obliged
that.
to,
We're law-abiding citizens.
Yeah.
Good. I'm really
Which
pleased
is
you are,
all
but you're
I'm
not a
saying.
party
I have
to
to
this.
go
Are
anyway.
you aware of the
Just
post
explain
office
why I'm
frauds?
here. I'd be very
Is this the
grateful to be
same?
kept informed
Is this the
by
same?
whoever, whenever.
This
so
is the
we
same.
protect our interests.
Right,
as well
I'm
as
going to
others.
talk to you because you obviously.
Do you understand
you're slightly
2006 Fraud Act?
If you could keep me posted, that'd be great.
We're going to go back to the court.
Yeah.
We're going to get a copy of the order and all that. Okay.
If I can just quote a case, which is Regina versus White. Now, this is the one of the prominent cases.
To be honest, I'm not interested in other cases. I'm
No,
interested in this
no.
one.
All it is,
So what I'm going to do now,
all I want to
I'm
inform
telling
you
you
is,
now, what I'm going to do now is we're going to withdraw, we're going to go back to the court, okay?
Yeah.
We're going to speak to the claimant as to why we haven't done it now, because obviously we have to report to them why we haven't done it. We will get the documentation and we will provide your friend with the correct documentation as you say is required. Okay? So as far as I'm concerned today, this won't be going ahead today.
you've got to understand, from her point of view,
I understand what
that
you're saying.
all the ones I've been to before, because this is a letter from the claimant, from a solicitor, to say it's going to happen at 12 o'clock. Now, she's given me the wrong documentation. There's another.
Have the right
Yeah,
documentation.
no, yeah, no.
You've just spent 15 minutes telling me
I've
I've got to have the right documentation. You haven't got the right letter.
Let me show you on the phone because it's.
No, I need to see. I need to see a
Yeah,
paper
yeah.
one. I don't want to see anything on the
Okay,
phone.
okay.
I need to see a real document. Right. What we're going to do?
Let me just quickly show you because normally because the claimant's put an application into court and it's been to court and they've got obtained the possession or whatever, the claimant is duty bound to notify the parties of the application and provide a copy of the court order that's been issued by the court, that's been sealed by the court, on what date to send it over. Do you know all they've done? Walker Morris, they've sent. Where is it? It's on the third page. You'll laugh at this. Bank of Scotland PLC, property in possession. This is on the third page. Take notice when the company obtains possession. So Walker Morris have sent 2-page letter. There's no name, there's no date or nothing. I can type that, you can type that. That is not satisfactory enough for them to notify.
That's obviously something that she needs to take up with Walker Morris. Yeah, that's nothing to do.
I'm just here to
we
make
can't control
sure
what the claimant solicitors do.
Can you tell us who instructed you from Walker Morris?
I can't tell you. We're not instructed by Walker Morris. We're instructed by the court. We're
They just-
directly operate. We're directly
They just get a
employed
job.
by
They
the
go
court.
in again in the morning. They get
And
a
we
job
get a
list.
job
And
and
there's
out
that
we
one
go
there,
and
that
do
one
it.
there.
Can you
So
tell me
you've
who
got
your line manager at the court is?
My line manager is the delivery manager, or is the operations manager, Anne O'Neill. Mrs.
Anne
O'Neill.
O'Neill.
And you see the operations manager for Brentford.
For Brentford.
Brentford County Court.
And who does she answer to?
She answers to the regional manager,
Who would that
Mrs.
be?
Jones.
Is it Mrs. Jones?
Mrs.
or-
Jones.
Right. Listen, I'm not here trying to be obstructive in any way.
Well,
I'm just.
you're
I
doing
just.
a good job of it.
Listen,
Talking
I just
about.
want to make sure that everyone's got the ducks in a row, like I say, because there is a process, and I've been involved in this several times before, as you can probably understand. And every single case where, like you say, obstructs an enforcement officer in the execution of his duty, every single one of them has gone to Crown Court, and every single one's gone to Crown Court. The judge has ordered the bailiffs to produce the warrant, the documentation they relied upon to force entry to the property. And every time they've produced that document that you showed me, and the judge said, no, that's not the document. And every single time it's been thrown out, and then the person's been awarded. I just don't want to listen. If we can go down that road, but we're talking 2-3 years down the line, we're all going to get in court. It's all going to get thrown out. So let's avoid it, because then it'll be a claim against
that's
you
what
and
I'm
your company.
That's what I mean. We work directly for the Ministry of Justice.
Yeah.
We're not private guys. that
Yeah,
you
I
see
know.
on the
No,
telly and all
these
that.
are
We
county court
county
bailiffs.
court
Can we,
bailiffs.
Yeah.
can we also add 2 other bits? One, you've got proprietary estoppel on this, which is a...
I'm really not interested in all that.
the other
listen,
thing-
the thing is with this,
and the
these
other
guys,
thing is-
unless we've got an order from the court, say there's a stay of enforcement, because of what's his name, an order from the court to put a stay, or there's an abusive process, or like we're discussing now, we need to make sure that all the correct documentation and the procedure being followed.
You've also got
then
adverse possession.
It'll have to go, be put off
because
to
it's
another
over
day.
12
So then
years.
she has.
Like I say, we're going to postpone it this morning, okay? We're going to go back and get the documentation. I'm going to speak to the judge and explain what's happened today, and speak to the solicitors and explain to them.
And are you back later?
Hold on.
Oh, we will inform the occupier when we're coming back. You're not a party to the case. I don't
Toby,
need to.
Toby has
Trevor, I've got
permission
I
to
don't need to.
Listen, there's new rules being changed. They can't.
I'm done with talking now. We're going to go back to the court.
I know that the things have changed now. No, you can't just say like no. She's got to notify the occupier and give them a time and a date.
Yeah, absolutely.
She has got an application. I don't know if you're made aware. She has put an application.
She made an application this morning into
She's
court.
also vulnerable.
Right? She made an application to court this morning. The clerk, or yesterday, it was put in yesterday.
It's been listed for a hearing.
It was put in before the judge this morning, and they are, because obviously if the judge had listed it this morning, we wouldn't be here.
That's right.
So the judge,
They've got back
they spoke to one of the judges in the court this morning. They said, he's instructed his work, yes, list it, but the eviction is to go ahead.
Exactly, I understand that. I mean, from my point of view,
I don't really want to stand out here in the pouring rain, getting wet for nothing.
See, from our point of view, your point of view, it doesn't make logical sense, because if her application didn't have any merit, it would have just been dismissed. But because they've listed the hearing to set aside this, it makes
but he's obviously he's given the order for it to go ahead. That's why we're going to go back and talk to the judge now. We need to speak to the thing. Obviously, as we're walking away today, we're going to give her another set. It's going to be a minimum of 7 days notice we're going to need to give her. We'll explain that to the solicitors and the bank and all that. But once we've got all that things in place, then we will be serving a new notice on her.
Nobody will be back today.
No,
I've just said it's going to be 7 days notice.
They have to by law. If they're going, listen, he's got a lot of work to do. He's got to go back. Judges are busy. He needs to go before a judge and check that he's done all his ducks are in a row.
Right. So
I've got to talk to the agent.
Okay.
I'll speak to you.
All right, mate. Good afternoon. Cheers. See you later.
Good job.
Walker shape. Nice one. Well done, folks. Well done.